Good morning, everybody. Welcome to a webinar on Brexit, trade and taxation. This event follows on from other successful events held physically at the Centre for Commercial Law Studies by our Institute of Tax Law. As everybody else, we've had to adapt to the new reality of Zoom teaching and seminars, which I sincerely hope will only be temporary. Now to our topic. Whichever position each one of us took during the Brexit debate, the fact is that the UK has left the European Union, and in a matter of days, the transition period will end. When I began planning for this event, I was hoping there would be a deal by now, but unfortunately the uncertainty persists. As the 1st of January draws close, I can think of no better person to talk to us about this topic than Dr. Timothy Lyons QC. Timothy is Queen's Counsel at 39 Essex Court, but also a practicing lawyer in the Irish Bar and the Brussels Bar. Timothy is a regular guest speaker on our EU tax law module and is extremely knowledgeable in many areas: European law in general, trade law, tax law. Over to you, Timothy.
Well, thank you very much. And it's very good, everybody, to be able to spend some time with you talking about Brexit, trade and tax. I'm not sure that I am anything like as optimistic as Christiana. I doubted very much whether by the time I began this seminar there would be a deal. I have to say I'm really rather doubtful that there will ever be a deal. But it does seem to me that there are some really interesting things we can say about Brexit, about trade and tax. But I don't want to spend the whole of the hour that we have talking about the negotiations. I mean, if there's one subject that everybody ought to know about, it's the negotiations, and we're probably all slightly tired of it. So I thought I would look at tax and the UK in the context of the negotiations, of course, but also in other contexts as well. So for the first 15 or 20 minutes, I thought maybe we could talk about tax in the Brexit negotiations, then talk about the UK as a third country in the context of tax, talk about tax and the Northern Ireland Protocol. People don't seem to talk about tax and the Northern Ireland Protocol, and I'm not sure quite why. And then let's leave the withdrawal agreement and the protocol and the EU altogether and talk about post-Brexit tax in the United Kingdom in the context of trade agreements that we are now agreeing with other countries. I mean, I have particular attention paid to Japan, but there are many other countries as well, as you know. And then finally, I thought we might, just to send you on your way rejoicing and thinking, think a bit about the UK's external tax strategy post-Brexit, post a transitional period. What is it? Do we need such a strategy? And if we do, what does it look like? Okay, well, let's start then with the first of these sections, which is tax and the Brexit negotiations. Now, we have all heard, till we are, I think, profoundly tired of the phrase, the level playing field. And we have all been told that this is kind of central to the negotiations. It's causing a great deal of problems. We're told that it's to do with business competition. If one listens to the BBC, which is not necessarily advisable, but no doubt sometimes we do it, you would not think it had anything whatever to do with tax. So where does this concern with the level playing field come from? One place it comes from is the political declaration, which, as you know, was specifically renegotiated. And it includes a phrase that the parties are committed to uphold common high standards at the end of the transitional period In the areas of state aid, I've put some dots there, but there's also labour policy, environmental policy, climate change, and relevant tax matters. And the parties should in particular commit to the principles of good governance in the area of taxation. Now, you can imagine an independent country not being too thrilled about that, and to the curbing of harmful tax practices, whatever they may be. Some cynics might think that the whole point of Brexit is that the United Kingdom can enter into harmful tax practices. But we have the key phrases highlighted there: relevant tax matters. Relevant is a marvelous word if you're a diplomat and you're a negotiator, because you can agree that you're only going to deal with relevant matters, and then you can subsequently, some way down the line, disagree about what those relevant matters are. But relevant tax matters is in there in the political declaration. Tax is in the heart of the level playing field debate. But whatever you do, don't think that the level playing field has suddenly come to life because of Brexit. The level playing field is an important element of the EU's thinking generally in its relations with third countries, generally. It just so happens that it's become important in the context of Brexit. And if you want to see this fully spelled out, you have to look at the EU's external tax strategy for effective taxation, which is actually January of 2016. It's before even the referendum. And even there, it is telling us that certain negotiations were delayed because third countries found the wording of the clause on the scope of good governance requirements to be unclear and were worried about it. So the UK is not the first country to find the level playing field troublesome. It is part of the EU's general approach to the world, which is to say, we are prepared to give you access to our single market if we compete on what we consider as a level playing field. Now, you may, from a different political perspective, say, well, that's really the export of EU law. And that may be so. But I would suggest all large political groups do, to some extent or another, export their law. Think of FATCA in the United States, and the EU certainly. But large political blocs, because of the economic and political power they bring, feel that they do have the power when they're negotiating with other people to export their law. So in a sense, that's what the external strategy for effective taxation does. But the important thing to bear in mind is that the roots of the level playing field debate are not anything to do with Brexit. They are to do with the nature of the EU and its view of the world and its relations with third countries. Now, if we then move, having seen that general perspective of the level playing field, we then move to look at the respective negotiating texts of the UK and the EU. Now, I don't know about you, but when I was an undergraduate, it was banged into my head by the predecessors of people like Christiana, that actually, when one's looking at an agreement, one shouldn't look at what the label is. Just because something says it's a license doesn't mean to say it's a license. It might be a lease. You can't rely on the title. Well, okay, I acknowledge that, of course, But it nevertheless is instructive to look at the title of the two draft negotiating documents we have. On the UK side, we have a comprehensive free trade agreement. I've said plus Metzides because it seems to me that's the only way sensibly to describe it. There are side agreements on fisheries, aviation, and all sorts of other things. They're put to one side. The focus is on free trade. The EU, on the other hand, what does it come up with? It comes up with a new partnership with the UK. And so we have an entirely omnibus agreement which looks to establish a long-term relationship with the UK over the coming decades and describes itself as a new partnership. And I just ask on that slide, is anybody surprised that agreement is difficult? Because these two negotiating blocs are starting with entirely different aims. One wants a transactional relationship about trade and focuses on, if you like, a commercial relationship. The EU, on the other hand, is talking about a new partnership, which is something really quite different. And you might say, well, actually, the whole point of Brexit was that the UK didn't want a partnership, leave alone a new one. So actually, although one shouldn't place too much emphasis on titles, these titles do actually tell us that the two parties are coming from enormously different perspectives. And nobody should find it surprising that it's difficult to find a landing zone. I mean, I know all sorts of terribly clever people, from investment bankers to political analysts and so on, have identified landing zones. Well, of course, you can, in the abstract, find lots of landing zones. But if you bear in mind that the political perspective of these two parties is entirely different, then the landing zones actually really do seem to become pretty small. And if you're landing in fog, you're quite likely to miss them. And if you think that landing in fog is a good metaphor for these negotiations, I'd be inclined to agree. Well, now, let's just have a little look at what the EU wants in this new partnership. The level playing field, section 2.1, 2.25, 2.26, tells you that they're worried about state aid, they're worried about tax good governance, and they're worried about standards. And one thing that I think I'd highlight there is tax rulings. We know that there have been all sorts of interesting cases, and lots more coming, on tax rulings and state aid. But tax rulings are a particular element of the level playing field. Now, think about that in the context of tax and the level playing field. And particularly think about that if one's political ambition is to create a low tax area which can access the single market. It's very unlikely that if they're your political ambitions, you will really want to live under the same provisions in respect of tax rulings as the EU. The UK's draft, again, is enlightening. Of course, it uses the same words. It says, okay, we're into good governance too, guys. But for us, it's an international matter. And we're concerned with international cooperation in the tax area. We're concerned with the OECD principles. We're concerned with OECD minimum standards against base erosion and profit shifting, etc., etc., etc. But you can see that that is an entirely different perspective of the level playing field. The level playing field that this draft wants to establish is a level playing field on international standards. The level playing field that the EU wants to establish is a level playing field on EU standards. And as I say, no surprise is it that there is a conflict between these two. From the perspective of tax, the elements of tax which go into the level playing field are, to some extent, substantive tax rules, no harmful tax measures, and then tax rulings. Then you have the difficult problem of enforceability in respect of this. And so you can see that the conflict between the new partnership, which the EU wants, and the transactional relationship, which the UK wants, is set to continue. Now, I mean, maybe when Boris Johnson looks into the eyes of the President of the Commission, he'll suddenly find a way through this, and they'll come out holding their hands and telling us that there is, after all, a new transactional partnership. It seems to me a kind of strange thing, and I'm bound to tell you that I think it's not altogether likely. But if it happens, it will be very interesting to read about. And no doubt Christiana can put on another webinar because it'll be a first, I think. Well, now that really is all I want to say about the negotiations. I think it's probably all I can say about the negotiations. We're told that, at least just before this started, it seemed that Boris Johnson might well end up in Brussels in the next day or so. People apparently don't know when. And I was rather amused to see one briefing from an investment bank who said that he would be flying to Brussels. I mean, clearly investment bankers do fly everywhere in private jets, and they have the notion that the man might get on the Eurostar was completely beyond them. But anyway, that I hope gives you a flavour of tax and the Brexit negotiations. And it does seem to me that tax is a sort of ugly sister. It's terribly important, but nobody seems to be talking about it. And it would be a jolly great help if they did. Okay. So now let's accept, as is a well-established fact, and has been since early on in 2020, that the UK is a third country. Now, what is that going to do to its relationships with the EU come agreement or no agreement? Now, a free trade agreement clearly requires the focus to be on the two parties to the free trade agreement and which are establishing the free trade area. It's concerned to give advantages to the goods of the parties. That's the point of it. It's a breach, of course, of GATT and the most favoured nation rule, but it is allowed under Article 24 of GATT. Given that a free trade agreement is designed to give advantages to the goods which originate in each party, the draft agreement of the UK was something of a surprise, because they said in their draft agreement that they wanted a product to originate in a party, but that's to say, let us take for this example, the UK, if it's used in production there, or if it originates in the other party, well, that's fair enough, or in a relevant partner country, or in a country of the generalized system of preferences. That's rather a lot of countries. A relevant partner country would be a country with which the EU has an agreement. So we are talking about a product originating in the UK, but which actually has links with a vast range of countries. And all of a sudden, I found myself asking, oh, did the UK want a free trade agreement then, really? Or does it want something else? It wants a transactional relationship, certainly, but it wants to protect its supply chains, its manufacturing chains, and they're international. And they're going to be interrupted if an international supply chain is not able to be regarded as producing a UK product. And so that's why we have this draft provision, which was, as you will recall, very quickly dismissed by the EU. But it is worth asking, really, although we start out wanting a transactional relationship with the EU, do we really want a free trade agreement? We want a free trade agreement, but really on very special terms. And of course, I'll just run through these quickly. The impact of being a third country is not just felt by UK businesses, but it's also felt by EU businesses. Because if you're an EU exporter to a third country, and you've got the UK in your supply chain, all of a sudden, that might be terribly, terribly, terribly inconvenient, because depending on the value and depending on the significance of the UK element in that supply chain, it may denature your ultimate product so that it's not an EU product for the purposes of the EU trade agreement. And so, frankly, EU traders will be looking at their supply chain saying, can we really afford to have the UK in? Because if we do, what does it do to our export capacity? And that will obviously be pretty much governed by the nature of the product in question, by its value, the value of the UK element, what it is, and the particular rules that apply in respect of the export market of the particular manufacturer you're dealing with. You can't deal with this on a general basis. It has to be specific. And then, of course, moving on from that, we've got things like UK binding origin rulings, UK binding tariff rulings, a whole host of authorizations in a customs system, because, as you know, one of the key elements of any customs system is that it authorizes people to do things. It authorizes traders to get certain privileges, and all of those authorizations, if they're coming from the UK customs authorities, will no longer be valid in the single market. And then we have, and I'm not going to explain this in great detail because it's jolly nearly 300 pages, we have something called the border operating model and the goods vehicle movement service and the Kent access permit. I'm not going to go into details about that. You can find it on the web if you really are fascinated and an insomniac. But it's rather interesting, I think, to notice that if you are now going to move goods from, let us say, a continental country to Ireland across the UK land bridge, you're going to have the pleasure, amongst many, many other things that you have to deal with, of putting on your smartphone 4 apps, one for the continental country, one for Ireland, and no less than 2 for the United Kingdom. And that's before we start to talk about anything more serious. I mean, obviously, the increased use of transit regimes, well, that's all very well, but of course, you do need guarantees often in these transit regimes. So just to say, oh, well, it's fine, you know, we can go across from the continent to Ireland and use transit regimes. Yes, you can, but they have significance. And so that is why, very wisely, the powers that be, in conjunction, I think, with the Danish operators, are setting up new sea routes between Rosslare and Dunkirk, so that actually you don't use the land bridge, which incidentally one senior Tory politician suggested the UK should charge for. It's almost medieval, really. You use my bridge and I charge you. I mean, this goes back to the commerce of the 16th century, as it seems to me. However, I think one can, as it were, make fun of it, and no doubt one shouldn't. One should be much more respectful. But it is important because it shows you that the UK's attitude to all of this is transactional. Seems to me that's the key thing about all of this. The UK has a transactional view of foreign policy. It doesn't really go for these new partnerships. Well, and other things that one might think about in terms of in terms of deal or no deal, well, we have VAT, which we now start to deal with in imports and exports. You might want to look at the limitation of benefit provisions in your tax treaties. You might want to look at the extent to which direct tax directives are enforced. Then there are instruments for cross-border cooperation. And certainly, so far as customs is concerned, access to EU databases, which is a huge and very important thing, which will be lost as a third country. So I think we can say that agreement or no agreement, being a third country has an enormous impact on the United Kingdom in the context of tax and customs. And perhaps really it would have been a help if people started to talk about Brexit and tax just as much as they're talking about Brexit and competition and so on. It hasn't really got into the public discourse, I think. What has got into the public discourse, and here's the third little element of this presentation, is the third country, the Northern Ireland Protocol, tax and the Northern Ireland Protocol. Well, the Northern Ireland Protocol has certainly got into the public consciousness. What has perhaps not got there is the impact of the protocol on taxation. And I think it's worth, if this is an area that you're fascinated by, interested in, then it's worth actually having a look at the European Law Review of earlier in this year, which had a special section on the withdrawal agreement, and particularly something by Professor Weatherall at Oxford on the Northern Ireland Protocol. And I'll come to what he said in a minute, but I think it's very well worth reading, or as is his blog. He's very outspoken and not necessarily wrong at all. I'm not criticizing him, but it is worth reading. So what is the protocol and what does it do in the context of, let us say, in the context of tax? And we all know that Northern Ireland is going to have about 22 pages of EU law applicable to it. And it's just worth noting that in the context of tax, Article 110 of the Treaty on the Functioning of the European Union applies to Northern Ireland. So that concerns with internal tax and protection and so on and so forth You've got things like the Mutual Assistance Tax Recovery Directive, and then you've got EU VAT and excise law on goods. We'll come to this in a minute, but EU VAT law on goods in Northern Ireland. And then we've got EU state aid law, and we've already seen that that might have an impact on tax rulings. Of course, state aid can be given in any form at all. I mean, it can be given by tax as well. It's worth having a look at that in more detail. And then Article 5. Article 5 is a very, if you're into smoke and mirrors, Article 5 is your dream made words, because we're told at the outset of it that there is no duty on goods going from Great Britain to Northern Ireland if there's direct transport, unless those goods are at risk of going on into the single market. So it looks, doesn't it, as if we've got a fundamental principle that basically you go from Great Britain to Northern Ireland, no duty, unless the goods are at risk. Article 5.2, in a masterstroke of magic that parliamentary, well, negotiators must have been excited about, goods at risk is rather interesting, because basically almost every good is at risk. The only way in which you're not at risk is if there's no commercial processing in Northern Ireland and the committee set out by the Joint Committee, the criteria set out by the Joint Committee are met. So 5.2 inverts 5.1. 5.1 says you're okay unless you're at risk. 5.2 says, well, good heavens, there's an awful lot at risk. And what are the Joint Committee criteria? Well, as far as I know, the Joint Committee, which has such luminaries as Michael Gove on it, I think, or at least associated with it, have not yet decided what those criteria are. They're crucial. We really don't know what the position is about goods and Northern Ireland and Great Britain until the Joint Committee has finished its work. Is it likely to finish its work before the transitional period ends? Well, I mean, I think maybe. If you're an optimist about life, and if you're a realist, well, maybe you take a different view. Now, I mean, I just put on this slide the significance of place taxation in the context of the devolution settlement in Northern Ireland. But I suppose what I want to do is to point out to you that both substantive and procedural law, tax law, is affected by the protocol, by this Northern Ireland protocol. Substantive law, because effectively we've now got, haven't we, two VAT systems in the United Kingdom. It's ironic, I mean, I digress, but it's ironic to think that, you know, we're in the United Kingdom now, a country that believes in one country, two systems. We set up that arrangement, as you know, in a particular part of the world. It doesn't seem to have gone down awfully well. But nevertheless, we're so committed to the concept of one country, two systems that we've applied it we're happy to apply it in the context of Northern Ireland and tax and VAT on goods. State aid law is interesting. I highlighted that a bit earlier. Let me mention it to you because, look, EU state aid law applies in respect of measures which affect trade between Northern Ireland and the Union, which is subject to this protocol. Now, you ask yourself, what measures affect trade between Northern Ireland and the Union? Now, that phrase, affect trade, in the context of state aid law, is very, very broadly interpreted. it seems likely it will be very broadly interpreted in the context of the EU, in the context of this protocol. So in fact, although this looks like something which might affect only tax in Northern Ireland, I'd suggest to you that it's possible it also affects tax in Great Britain as a whole. In fact, this protocol has really quite profound impact on tax policy of the United Kingdom. And we've already seen that tax rulings and state aid are inextricably linked. So the protocol has, just like the level playing field provision, very significant provisions which affect tax. They haven't been carefully enough looked at, in my view. And I don't support at all the notion that the United Kingdom should seek to break a protocol which it has negotiated not very long ago. And in that, I'm with not only people who were Remainers, but also people like Michael Howard, who are very much in favour of Brexit, but very much against the override of the protocol. But I think you can see that actually, from the perspective of this government, the protocol could be immensely limiting, not just in Northern Ireland, but generally. So you can see the incentive. Now, I mean, my answer to that is you should never have agreed it. And certainly in Brussels, people say to me, Timothy, I don't understand how a United Kingdom government can agree this protocol, but nevertheless you have, so there you are. Mrs. May said no Prime Minister could ever agree to a border down the Irish Sea. She was right. The result of that was that she put the whole of the United Kingdom in the backstop. Well, I have considerable sympathy for that. But it does lead me to worry about what will happen to the protocol in the long term, or even in the medium term. I'm sorry to say, I feel hugely sorry for Ireland in the context of Brexit. It's, especially in no deal, it's going to suffer enormously in all sorts of ways. But I really do think this protocol is going to be a source of real conflict in the future, and I fear for it. Well, I mentioned to you that the level playing field produced some interesting administrative results. You ended up with your smartphone full of apps if you wanted to do anything so horrendous as to go from the continent to Ireland via the land bridge. There are some pretty interesting administrative results which come from the protocol as well. We have 3 codes now for the UK in customs administration. There's a GB code, which is the country. There's another code if you're excluding Ireland, and another code if Northern Ireland, and another code if you're just looking at Great Britain. So that, if there's a code if you're looking at Northern Ireland, and there's a code if you're looking at Great Britain, and then one if you're looking at the whole lot. So that's rather exciting. And of course, I've already mentioned to you, you end up with one country, 2 systems. I thought that I might say something about the Internal Market Bill and the Taxation Post-Trial Decision Period Bill. Well, I mean, I really, you know what happened last night in the House of Commons. And clearly, these 2 areas are going to be terribly important in the future. Just to say this, that I really don't understand how it is possibly reassuring, if you are in the EU, to hear the British government tell you that they won't press ahead with these provisions if there's a free trade agreement. I mean, of course you wouldn't. because these provisions override the protocol, and we're really only worried about the protocol if there's no free trade agreement. So how does it really reassure you to know that if you've got rid of the protocol, it won't be overridden? I mean, I think it was Laura Kunsberg on the BBC who said that this was an olive branch to the to the EU. Well, I mean, maybe it is, and maybe I'm mischaracterizing the sophisticated concession which the United Kingdom is making, but it didn't seem to have many olives on this olive branch to me, is all I'll say. Okay, well, so we've looked at the level playing field and Brexit. We've looked at what it might mean a little bit to be a third country and tax outside the EU. We've looked at the protocol. Let's, in the last few minutes that we've got, and I'll try and stop in about, 7 minutes time in order to let you discuss things. But let's talk about Brexit and trade agreements, because, tax lawyers have had a slightly neuralgic reaction to EU law, or some tax lawyers, I should say, have had a slightly neuralgic reaction to EU law. What does EU law do to our tax system? You remember Lord Walker's characterization of a ruling of the Court of Justice of the European Union as a thunderbolt from Luxembourg, as if Luxembourg was sort of somewhere around Mars. And everybody worried about what does EU law do to tax? Well, we've got some new questions now to be neuralgic about, if that's your tendency. If there's an agreement, what does the EU-UK agreement do to tax? Well, we don't know because we don't have an agreement. What do UK and WTO agreements do to tax? What do UK free trade agreements do to tax? What is the relationship between trade law and tax law? Now, you can look at the American academic literature in this. I've written something in the BTR, that's the British Tax Review, that's coming out shortly on the Japan trade agreement and UK tax, and I've given some of the literature on this. But it seems to me that lawyers in the United States have always confronted this notion of what does trade law do to tax in a way that we never have, because we've always transformed that into an agreement, into an argument about what does the EU do to tax? What does EU law do to tax? We've now got, if you like, the purer form of this argument to worry about after Brexit and after the transitional period. What do UK tax of trade agreements do to tax? And how should we see tax and trade generally? We just got a little taste of the fact that the United Kingdom government is well aware of this important interface in the last Finance Act in '97, because there was an amendment there to deal with the extent to which the Secretary of State could be authorized to retaliate in a trade war. The law prior to this provision was that you had to be, if you were the Secretary of State, authorized under international law to retaliate. Now, retaliation perhaps is going to be a much more serious theme. People have thought about that and say, well, actually being authorized under international law is quite a tight constraint. Perhaps all we need to do is to have regard to international arrangements and so on before we retaliate. Have regard to, be authorized under. That's the relationship between international trade law and WTO provisions in this context of this provision, and tariff and tax law. That's important. Moving to agreements more generally, you can, of course, if you're going to negotiate an investment or a trade agreement, just say something very simple, like the provisions of this agreement don't apply to taxation. Well, the Danes and the Russians said that in a bilateral investment treaty. But trade agreements, generally speaking, don't say that. They say something much more complicated. And you will see, I've given you the opening phrase from an article in the UK-Japan Treaty. This agreement applies to taxation measures only insofar as such application is necessary to give effect to the provisions of this agreement. And if you can't argue for the next 3 weeks about the meaning of those words, then I suspect you're not a lawyer. What on earth does it mean for the measures to be necessary? That's, I think, a rather misleading word. It carries connotations of objectivity. Well, it sort of stands outside a situation and it becomes necessary. But in fact, necessary is a word that is subjectively understood. What is necessary to me is optional to you. Just ask the Brexit negotiators. And what on earth does it mean to give effect to? Well, again, you can debate that for a very long time. And this might look like a tax exclusion clause, but it isn't actually, is it, really? It's a tax inclusion clause. It says that tax is subject to this agreement where it's necessary to give effect to the provisions of the agreement. So, happy days. The trade lawyers have brought the tax system into their world. And we can have a lot of fun debating about that. I should just say that that's not the only article in the UK tax, in the UK trade agreement with Japan that covers tax agreements. You've also got protection for tax agreements, although that is very, very difficult, and it involves the tax administrations of both sides at some point being coming to agreements. Well, I mean, that's optimistic, I should have thought. And then there's protection for effective or equitable imposition of tax. What on earth is effective or equitable imposition of tax? And then we notice that subsidy in the trade agreement also includes tax concession. Well, that means, I think I will do this very quickly, but it means that you can have a whole career looking at the tax provisions of trade agreements and the tax implications for trade agreements if you want one. And that is a new world that we're going to be able to engage, to explore after Brexit. Finally, just to come to an end, final slide. The EU had this external tax strategy. We saw how that inspired the level playing field, how that effectively, if you wanted to look at it this way, it was the export of EU law in some respects. And this is what you need, isn't it, if you are an international player hoping to shape the world to your way of thinking. And that's what this is about, and that's what Britain, after all, wants to do. And I don't complain about that. I mean, independent trading countries, independent trading blocs, always want to shape the world in their image. But if we're going to do that, do we have to have an external tax strategy? And even if we wanted one at the minute, could we draw one up? Because one advantage that the EU has in the Brexit negotiations is that it knows who it is. It knows what its internal policies and laws are. It hasn't got to necessarily establish them from scratch. It may well be in a position where they're going to develop, but it knows where they're developing from. The UK, on the other hand, is now in a position where it's developing for the first time its independent environmental policy, its independent trade policy, independent policies in all sorts of areas. And so one question I would ask, not just should we have an external tax strategy, or what should it look like, but really, can we formulate an external tax strategy at the moment? Because domestically, internally, our policies probably are not sufficiently articulated and firm for us to be able to think about how we might want to impose certain things on the rest of the world when we're negotiating. So, ladies and gentlemen, the level playing field and all of that, it's not just about Brexit. And of course, before Brexit happened, tax lawyers had to worry about overriding principles of EU law. Now, actually, we still have to worry about overriding principles. So if the objection was to overriding principles, I'm afraid this has not been a terribly successful activity. But what we do know is that the overriding principles that we now have to apply are going to be different, we hope, or the UK government hopes anyway, from the ones that it's had to apply in the past. There we are. The more things change, the more they stay the same. And that's as true for tax as it is for anything else. So that brings me to pretty much the end of the things that I had planned to say. At least according to my watch, there's 5 minutes left. I don't know whether the official timekeeper has the same notion of time as I do. But Cristiano, what do you want to do now?
Well, first of all, thank you very much for a fascinating presentation. I think you've given us a very realistic overview of the issues that persist with or without a deal. And I leave with more questions than answers. And thank you for your honesty in setting all of this out. We have one question a bit earlier on from Kevin Webb. Would you agree that the average citizen of the UK is unable to comprehend the complexity of decoupling from the EU? I think I would say not just the average citizen, even the more experienced lawyers, but I'll let you handle it.
Well, look, I mean, I think there's a problem here because citizens never understand the technicalities of any law. So one shouldn't, I think, expect citizens to understand everything. And indeed, that is the point of a representative democracy. It's one of the dangers of direct democracy. Representative democracy says we pick these people to understand things for us and make laws. Direct democracy says we know what we're doing and we're going to do it. And representatives are rubber stamps. And if Brexit shows us anything, it shows us the importance of Edmund Burke's notion of representative democracy. But you sure? I mean, I'm quite sure that people have not thought about the technicalities of what we're doing, or even in tax terms, for example, the non-technicalities. I guess we just have to live with that. It's far too late now to think that we can start explaining them.
Timothy, can I ask a question? Because we've got lots in terms of how individuals react and voted or didn't vote and what they think. And as you say, the BBC isn't necessarily the right place to get informative. If we move the clock forward a little bit and we think about your comments, particularly in relation to the Japanese a trade agreement.
Yeah.
Do you think something in the order of some sort of guidance note to it is something that could now be prepared to start to thresh down in some more detail what we actually do regard by necessary and how we really do think tax ought to be linked into that? Do you think that could be helpful?
Well, thanks very much for that, Joy. I mean, I think that really is very, that's a very positive thing to suggest. And the answer is yes, I'd suggest. But against that background, I suppose one should say that these problems which arise with the UK-Japan treaty, of course, also arise with other treaties that the UK has signed. I mean, I don't want people to go away with the idea that somehow this is a specific problem with UK-Japan. It's a problem of trade treaties generally. And a lot of what comes out of this, you can find the same problem in the General Agreement on trade in services, for example, and the WTO agreement. In fact, there's a footnote in the Japan treaty which comes directly from the GATS treaty. The footnote is almost word for word. And it also has to be said that the UK-Japan treaty in this respect is pretty much like the EU-Japan treaty. So these are problems of trade and tax generally, which have been around actually quite a long while. It's just that we now have, for the first time, to face them as an independent nation and make our minds up about what we think. Yes, I mean, I think it would be helpful. I don't know whether the trade negotiators themselves have such notes. They may or may not think it would be helpful to have such guidance. I mean, there is such a thing as constructive ambiguity. And maybe the fact that when you really ask for precision, nobody knows what these clauses mean, is a very helpful thing, because it means we can keep on signing agreements with them in, and nobody has particularly to make them a focus of negotiation. I mean, I think that you and I would find it helpful, companies would find it helpful, whether negotiators would find it helpful is quite another matter.
Indeed, it's a complicated world, isn't it? But at least that would be a start to formulate
some
sort of domestic policy.
Yeah, and that would, I think that would begin to help you draft an external tax strategy, because you would be beginning to delineate the boundary between trade and tax law.
And having worked in tax for a very long time, I go back to the very beginning of the UK entering the European market and several years in the early 80s where we actually didn't think that EU law applied to tax.
Yes.
It's quite interesting to see how we've come full circle, to see that
yes, indeed.
in a very big way.
Yeah, no, it's very interesting.
Professor Joyce Vastisali is is a professor at CCLS and our executive director at the Institute of Taxation, just to those of you who don't know you. Timothy, I have a question, if I may. It might be a little bit broad, but do you think with this new era, we're moving away from efforts for multilateralism to more unilateralism, but in a different way? The EU wanting its own external strategy, the UK wanting to develop something like that. Whether it will be successful remains to be seen. Well, the US has been trying that in the last 4 years. So do you think this will formally be a shift away from efforts for more multilateralism, more solutions like multilateral solutions, and more sort of unilateral, but maybe sort of on a wider range, like bloc basis, a EU basis, or UK or US?
We may be, but I think this tension that we're now seeing actually has been there all the time. It's been there all the time that there has been multilateralism. I mean, the EU, for example, has had its commercial policy effectively all the time. Its foreign policy, when it started out, years ago, was almost its customs policy. because trade is such an important element in the relationship between countries. I mean, the common market, you know, everybody said, well, of course, that doesn't really have a foreign policy, but I mean, I would say, well, to the extent that you're putting a customs barrier around the European Union, actually, well, if that's not foreign policy, I don't know what is. I mean, so I think what you're highlighting is something that has always been there, but never perhaps been quite so clear. And I suppose the other thing I would say in that context is that I do suspect that we're moving to a world which is regionalized. And so we are going to be talking about the impact of different trade blocs on each other. The US is large enough to be its own trade bloc, if you like, but I mean, it's still in a trade association with Canada and Mexico. But you've also got an Asian bloc, which apparently we want to join, and you've got the EU. I mean, I think the world is regionalizing, and that may be that's a version of multilateralism, if you like, that we're probably going to see more in the future.
Thank you very much, Timothy. I think at this point, I will wrap up. It's been, as I said, a fantastic presentation. I don't know if you probably didn't manage to see some of the comments. A lot of congratulatory messages. Some people say I could listen to Timothy for hours. I think that speaks for all of us.
That's sure a very dangerous thing to say, if I may.
Yes, I did say I will try to convince you for a follow-up 2021 seminar, see what we have achieved. Thank you to everybody who attended, making this such a lively discussion at the end and in the chat. Merry Christmas, Happy New Year to everybody. And as I said, sincerely hope we can go back to normal soon. Thank you very much and keep safe.
Well, thank you very much. And thank you, Joy. Thank you, Christiana. It's always a pleasure to do something with Queen Mary and the Centre for Commercial Law. And thank you to all of those people who were brave enough to log on and stay to the end. That's very kind.